Yes, Miss Smiley, now you want to take us to another short case.
Yes. Sacharidis, tab 51, page 1162.
Bundle 2.
Bundle 2.
'61. Did you say?
Tab 6, no, tab 51.
51. All right.
So the facts are on page 1189. So essentially, Mr. Sacharidis, this is paragraph 11, had been born in Germany, and then he goes between running a pancake stall in Greece and committing crimes in Germany.
Versatile.
No.
So that's what happened, and essentially this case is considering a number of questions fundamentally relating to the meaning of imperative grounds. The questions are at paragraph 21. Again, what we've done is we've sidelined at paragraphs 49 to 55 the way that the ECJ says that the relevant conditions apply, but we should have started the sidelining at paragraph 48 actually.
So do you want us to look at the question, or do you want us to go straight?
I don't think the court needs to look at the questions.
Okay, so the question's about imperative grounds.
Straight into paragraph 48.
It's imperative grounds, is it we're looking at?
It's imperative grounds,
Not
yeah.
that matters greatly, I suppose. Right, 48. Would you like us to read 48 onwards?
Yes, please. It's a bit long, but
All right.
again, 48 to 55.
Okay. Metok.
Yes.
Rings a bell.
The reason I'm asking the court to read this is again, it's just, this is now post-directive, and it's the ECJ saying how to apply the various conditions in the directive.
I'm underlining 52. Is that the right thing to do?
I'm going to make 7 points, and one of them concerns paragraph 52.
One out of 7 is quite good for me in this jurisdiction.
They are very brief points.
Okay, all right. Let's get on to 55 then. Yes.
So,
Right, yes.
excuse me.
7
So,
points.
first point to note is paragraph 49 refers to the need for an individual examination of the specific case, but that requirement flows from the fact that the personal conduct has to represent a genuine, present and sufficiently serious threat. So it's not individual examination in a vacuum in that context. It's about the requirements of Article 27, Article 27.2 specifically. So you get an individual examination there because you're looking at the person's conduct and whether they're a genuine, present and sufficiently serious threat. So we would say it's not a general principle of proportionality, for example, that it's individual examination. This is a manifestation of the proportionality principle, and you look at individual circumstances because of the genuine, present, sufficiently serious threat requirement. It's just the way that it works. The second point is to notice that in paragraph 49, the proportionality test is conducted by reference to the relevant interest being protected. Here it's imperative grounds of public security. But we say in our case it would be the interest being protected by national legislation. In paragraph 50, you see the court conducting a balancing exercise, but one of the things it takes into account is the risk of compromising the social rehabilitation of the EU citizen in the state in which he's become genuinely integrated, not only in that person's interest, but also in the interest of the EU as a whole. And we say that imperative has clearly gone because the UK is no longer in the EU. And this is an illustration of the difficulty of trying to fill it out, bits and pieces, and saying they still apply now, when the UK has left and when national legislation applies. Paragraph 52, Your Lordship mentioned yes, because it focuses on private and family life.
Is this all part of the second point, or are you on to your?
Oh, I'm well into that. Was point 5. I should have numbered them.
Oh yes, sorry.
Sorry. So
I've lost the plot.
I'm so sorry. So have I. Paragraph. So the first point was about individual assessment flowing from personal conduct. The second point was the proportionality test is conducted by reference to the relevant interest being protected.
Yep.
The third point is that the imperative at the end of paragraph 50 has gone.
Yep.
The fourth point is that as part of the court's application of the relevant bits of the directive, which we say flow from the proportionality principle, it conducts a private and family life examination. At 53, what we say is we see the court there blending a number of factors, including the nature and seriousness of the offence as well as private and family life. And then sixth, what we draw from all of that really is that proportionality is intimately tied up with all the protections in the directive, and that it's very difficult to disentangle one from another. You won't have seen anywhere in that analysis a distinction being drawn between grounds and safeguards. The final point to make, and that was my seventh point, is that what you see the court describing all of that as is conditions. So at the end of paragraph 55, it's for the referring court to ascertain, taking into account all the factors mentioned above, whether Mr. Sakarides' conduct is covered by serious grounds or imperative grounds, and whether the proposed expulsion measure satisfies the conditions referred to above. So that's perhaps another way of describing, I described it as substantive protections. I also said it's constraints on the circumstances in which a member state can deport. The court here calls it conditions. So the conditions with which the member state has to comply when it's deciding whether it can deport somebody. The thought process is it has to go through the things it has to take into account, the threshold it's required to apply, and so on. They can all be described as safeguards, but what they're not, we say, is procedural safeguards in the sense that the directive understands procedural safeguards. So that's all I was proposing to say about Sakarides. And then the third case in the trio is K, and that is at tab 54, page 1255 of the bundle. And the context in this case is, it can be seen most easily from the head note. Basically, the claimants had been refused asylum and excluded from refugee status because they were considered to have committed war crimes. And then if you look down to H, the essential question that the National Court was asking is that finding under Article 1F of the Refugee Convention, is that enough to enable the member state to take measures under Article 27(2) and 28? So the first thing to note in this decision is paragraph 41, and that refers to the concept of public policy. And what it does is wrap up within the concept of public policy that you have to have a genuine, present and sufficiently serious threat.
Yes.
And then at 61, we have the court setting out the classic exposition of the proportionality principle. So 61, a measure which restricts rights may be justified only if it complies with the principle of proportionality. And then it spells out that that assessment entails, in other words, what proportionality requires is that the threat that the personal conduct of the individual concerned represents for the fundamental interests of the host state. So you look within that at the threat that they pose by virtue of the genuine, present, sufficiently serious test against the protection of the rights which EU citizens and their family members derive from Directive 2004/38. So you're looking at all the specific protections that they get from the directive, and then we see at 63,
Yes.
again a reference to fundamental rights. 64, again a reference to is it possible to adopt other measures less prejudicial, but the case cited there is one of the cases I mentioned about stopping somebody from leaving in order to enforce a debt. So that's obviously quite an easy situation to see where the proportionality principle might bite, because you might have another way of enforcing the debt rather than banning them to leave. It's more difficult, we submit, in the current context. What more does it do than pretty much be the grounding for all the protections in the directive? And then the court doesn't need to read them now, but again, we would submit, again, as with all the other authorities, the analysis at 65 to 67 shows very much how all these different manifestations of proportionality, which find their way into the directive, are very bound up with one another. So, drawing the strands together before I move on to the withdrawal agreement then, 3 points. 1, we say, looking at the recitals in the directive and the case law, we see that proportionality is the inspiration for all the protections in the directive against restrictions, and by that I mean the various substantive constraints it imposes on the member states. Second, we submit...
Well, substantive and procedural safeguard.
No,
So,
I'm talking there about Articles 27 and 28 effectively.
Okay.
Second, there's no basis, we submit, for saying that only one or some of the provisions in Article 27 and 28 express the proportionality principle. We say they all do. One of the submissions that's been made is we'll just apply Article 21 because that's really proportionality, and for the reasons I've given we say that that's wrong. And nor we say in any of that is there a basis for a safeguards versus grounds distinction. It's not there. There is, we submit, starting with the recitals, a very clear basis for distinguishing between circumstances in which somebody could be deported on the one hand and procedural safeguards on the other. So moving then to the withdrawal agreement, which is in the first authorities bundle at tab 17. Just to remind the court at this stage what the proper approach to interpretation of the withdrawal agreement is, and for the court to note that is captured by this court in the Fertray case.
Yes.
At tab 82. We don't need to turn it up. Sorry, it's not at tab 82, it's at tab 45 at paragraph 82. But I'm just going to remind the court what the proper approach to interpretation is. It is to establish by objective and rational means the common intention which can be ascribed to the parties, so objective and rational, and do that by considering the ordinary meaning of terms in their context and in light of the treaty's object and purpose. Now, to be clear, we are not inviting the court to make assumptions about the negotiating position of the parties in this case, what we're doing is asking the court to give effect to the clear intention of the UK and the EU as expressed in Article 20, sub 2. Could we start with the recitals? They're not numbered, annoyingly, but the first considering basically records uncontroversially that the UK has left the EU, and the fourth recital, which is by the bottom hole punch, says the law of the Union in its entirety ceases to apply to the UK from the date of entry into force of this agreement. Recital 5, the objective is to ensure an orderly withdrawal of the UK.
Sorry, I'm having trouble. Where was the first one you cited?
The first one starts considering.
Yes.
The fourth one starts recalling.
Yes.
The fifth one starts stressing.
Yes.
The sixth one's, it's amazing they came up with all of these different words. The sixth one, recognising.
Elegant variation.
They
They
are.
probably spent more time on this than working out what.
Would it be helpful if we just numbered them?
Yes, I
now,
have to
and
number them
then
every
it's
time.
easier to
Yes, so
refer to them.
I make there's 7 on the first page.
Yep.
The rest don't have to be numbered.
Right, so you were drawing our attention to number 4.
4, 5, 6 and 7. So they're everything from the
Yeah.
bottom hole punch onwards.
Yeah.
So, can I just make a few points about these? The first point is the court seeing the reference to orderly withdrawal. We submit if there is an interpretation which results in clarity rather than confusion, that is the interpretation which ought to be adopted. And we say that, and we've made this point in our skeleton, that the position being taken by the other parties is really a recipe for confusion, and we rely on the fact that given the complexities of the protections in the directive, given the way they all interact, and given the clear language of Article 20, and given that what was wanted was an orderly withdrawal, it isn't an objective and rational interpretation of this agreement to say that that must have all just been left hanging. In relation to recital 6,
So you say that's the common intention,
the common
applying Anson.
yes, and a rational interpretation is that they wouldn't have left hanging quite how the protections in Chapter 6 were to continue applying. They would have said, well, the point's probably better made when we get there. The 6th recital is just to note that the reciprocal protection is where a person has exercised free movement rights before a date set in the agreement, but it's very fixed at what's happened before. And then paragraph 7, an orderly withdrawal and providing legal certainty, not just to economic operators, but judicial and administrative authorities as well. And then Article 4, we don't, Article 4 is on page 139, we don't, of course, dispute what AT says about Article 4 in principle, but we certainly do say that AT isn't otherwise relevant, and I'll come back to that at the end. It's been considered by this court quite recently in Fertray. So far as Article 4.1 is concerned, there isn't an issue about equivalent effect here, because the UK and the EU have agreed that all member states should apply their national legislation, see Article 20 sub 2, So there is going to be a different effect, but that's the whole point of the provision. And then finally, in relation to Article 4.3, we say there's no scope for Article 4.3 to bite on Article 20 sub 2, because Article 20 sub 2 doesn't refer to union law or to concepts or provisions thereof, it refers to domestic law. So, turning then to Articles 20 and 21, and I'm going to...
Do we need to look at Article 10? Because that's...
It's the scope provision, I don't think we do.
Okay, so
I'm happy.
there's no issue but that the personal scope
No,
requirements
not
are
in this-
satisfied here.
Not in
Okay.
this case. So we can now go straight to Article 20. Articles 20 and 21 for the Court's note are addressed in our skeleton at paragraphs 58 to 70. And the first point we make, and an obvious point we say, is that the two provisions need to be read together and in harmony with one another in order to give effect to the intention of the parties. The second general point we make is that Article 20 is the lex specialis in respect of conduct and criminality. So Article 21 needs to be read subject to it and not the other way around. Now, I'm going to ask the Court to just read Articles 21 and 2 together, but before I do invite the Court to do that, again, just to the reminder that what we're doing is being objective and rational to discover the common intention of the parties and the ordinary meaning of terms in their context and in light of the treaty's object and purpose. With that in mind, could I just invite the Court to read Articles 20 sub 1 and Article 20 sub 2 together? And we say when you do that, the meaning is completely clear. If you've committed pre-end of transition period conduct, you get the benefit of all of the protections of Chapter 6 of the Directive. But if you've committed post-transition period conduct, you don't. National law applies. Because those two provisions stand in direct contrast to one another. So, in one breath, if you commit conduct before the end of the transition period, Chapter 6 applies. To say in the next breath, in accordance with national legislation, we submit it really is very clear what is meant. Just to make some specific words on the language, both provisions use the words in accordance with. So one says you follow EU law, the other says you follow national law. The ground is now conduct. Now we say there's a very good reason why the word conduct has been used in Article 20 sub 2, because as I showed the Court, I think it was paragraph 41 of either Sakaridis or Kay, public policy has a very specific meaning. It wraps up within it the need for somebody to be a genuine, present and sufficiently serious threat, and it's a specific concept and is described as such. But conduct is not a concept. It's what somebody's done that enables you to take action. So we say that there's nothing in Article 20 sub 2 which brings in concepts of EU law. The reason that it uses the language of conduct may constitute grounds for restricting the right of residence in accordance with national legislation. It's essentially performing the same function as Article 27.1. So recall that I said Article 27.1 is the gateway, and then you go through that gateway, and Articles 27.2 and Article 28, etc., tell you the conditions with which you need to comply in order to deport somebody. Here, the gateway provision is you apply national legislation, and it doesn't need to go any further because national legislation tells you the rest. So connected to that point, and again it's an obvious one, but nowhere does it say in Article 20 sub 2 that some rules in Chapter 6 apply and some don't. It simply says national legislation. And given that it's said immediately previously for the cohort who've committed for the cohort whose conduct is before the end of the transition period, Chapter 6 applies, the only place that we would be told that the protections of Chapter 6 apply to the next cohort, which is post-transition period criminality, is Article 20 sub 2.
On this interpretation, what's the point of Article 21?
Procedural safeguards.
Why do you need that? Why could that not be included on your interpretation in Article 20?
Because Article 21 is covering more than the Article 20 cohort. It's covering a whole range of individuals, including those who have fallen out of scope of the withdrawal agreement, including those who've ceased to comply with the conditions in Article 13, including somebody who has been refused the Article 18 residence document. So it's actually covering broad ground, and given that it covers that broad ground, there isn't any need for it to say, but by the way, we didn't need to say that for the cohort above. That's what it's doing.
On the face of it, any decision includes 22, doesn't it? Why? What do you say any decision means in 21? Article 21, what does any decision mean?
So our point is that Article 21 is a broad provision. Article 20 is the lex specialis. Article 21 is covering procedural safeguards in the sense that the directive describes them. See, for example, recital 25, in respect of a range of decisions.
Any decision by the host state.
So it's a much wider class of decisions
Yes.
than the decisions which are covered by 21 and 22.
It is.
But why does it not include 22? Because you say it's national.
Well, it does.
But it does, but they don't need it. But it does include them as well. But it's just it doesn't. What it doesn't do is then unpick Article 20 sub 2, which is the provision which tells you what they actually get by way of rights. All it does is deal with the procedural position. So it's not that it doesn't cover them. What it doesn't do, though, and this is the case against me, is that the withdrawal agreement gives the member states with one hand, but then immediately takes away with the other hand in Article 21. We say no, it doesn't. What Article 21 is doing is providing procedural safeguards in respect of a range of decisions. It isn't undermining, Article 20 sub 2.
We've heard a lot about whether Article 21 covers procedural or otherwise. I hadn't noticed before, but 20 sub 3
Yes.
refers specifically to procedural safeguards.
Tick that submission off, but that.
Okay, sorry, you were going there.
Exactly. It describes, although Article 21 doesn't do it, and the directive, we've mentioned this in our skeleton, it often does simply use the word safeguards when it means procedural protections, but certainly if you read this sensibly, clearly what was thought, see Article 20 sub 3, is that Article 21 is doing something narrower. It's procedural safeguards.
Is there any other cross-reference to Article 21 within the withdrawal agreement apart from 23?
Yes, but I can't. It appears. Can I ask somebody to check that, my lord? Because I don't know off the top of my head. I think it certainly appears. I think in Article 18. Article 18, which is effectively the beneficiary document. I think yes. So, for example, it appears in Article 18(3), and I think here we can check that. do say is that nothing in Article 20 sub 2 or anywhere else allows a distinction, an unprincipled distinction, to be drawn between grounds and safeguards. Really, the difference now is not that the grounds are different as such. If a ground is a reason, fundamentally the reason will be the same. It will be somebody's conduct, but the difference is that the conditions that apply if you want to deport them or otherwise restrict their right of residence are different, because one cohort who've committed pre-end of transition period conduct gets the benefit of the EU rules, and the other national legislation applies. And the other point we just make here before I address some of the broader points that have been made is that in our submission it isn't satisfactory to say just apply the grounds that we want you to apply, and don't worry about everything else. What the court needs to do in my submission is come up with a coherent interpretation, and our interpretation, we say, is the only coherent one. It's been consistent from the beginning, and it gives effect both to Article 20 sub 2 and Article 21, and it allows them to be read in harmony, sensibly and as a whole. It gives effect to, we say, the common intention of the parties. It's clear and it's rational. Now, at that point, could I address some of the broader points that have been made, which is, it can't be that the contracting parties intended that an EU citizen could be deported for something very minor. Well, the point, I think, was levelled against the Secretary of State, or maybe levelled against the Secretary of State, that the Secretary of State is making assumptions. The Secretary of State isn't. The Secretary of State is saying, look at Article 22, it's clear what it says. But it is making an assumption to say, well, it can't have been intended that an EU citizen be deported for something very minor. So let's take a step back and remember that the UK has left the EU. And the effect of this provision now is that after the date of the UK leaving the EU, EU nationals in the UK and UK nationals in another EU state who commit criminal conduct after that date are simply in the same position as other foreign criminals in that state. Now, recall that the recitals pointed to the need to provide reciprocal protection where somebody had exercised free movement rights before a date set in the agreement, and ensure that the person keeps those residence rights. Well, they do. But what Article 20 sub 2 means is if, after the UK has left, they commit crimes, they're simply in the same position as any other foreign national, i.e. domestic legislation applies. And there is reciprocity because everybody gets to apply their national legislation. And taking a step back, we submit it's pretty clear why Article 20 sub 2 would be there. The UK has left. The protections are provided for anybody in relation to what happened before the end of the transition period. But after the end of the transition period, if you commit a crime, you find yourself in the new world on the same footing, for example, with an EU citizen who enters the UK on the 1st of January 2021. That person would be subject to the UK's national legislation. A third country national would be subject to that legislation. It's quite clear in our submission why the party should have said we're drawing the line at criminality. We submit the contracting parties proceed on the basis that choose to commit the crime after that date, then the states apply national legislation. The suggestion made that now somebody can be deported over a very minor offence, and we had the example given in the upper tribunal, is, well, what if a state decided that somebody could be deported because they played tiddlywinks? We say one has to approach this with a degree of realism. everyone is sitting around the everyone's sitting around the table with the EU member states and the UK being signed up to the European Convention on Human Rights. Everybody knows that when they sit down. Nobody's dealing with, is the word despotic? I'm not sure if that's a word, but nobody's...
Yeah. It is a word.
Okay. Well, when everybody sits around the table, that they're dealing with states with, and particularly in the case of the UK, long established and respected common law systems. So it's wrong in my submission to say, oh, well, they agreed that. They can't have done that because that just means that anything will go and somebody could just be deported. These are states who, despite the UK leaving the EU, have respect for one another and one another's legal traditions. And the parties made the agreement in the light of that current position, rather than in the light of a hypothetical situation in future where somebody gets deported for playing tiddlywinks. So taking a step back, we say absolutely nothing wrong in saying, if you commit crimes after the end of the transition period, you are subject to domestic deportation legislation. The court was shown part of the Commission guidance. Could I just invite you to read the part of the guidance that deals with Article 20 specifically?
What weight generally?
Pardon?
What weight generally should we attach to this guidance?
It's essentially the Commission's unofficial position, but if the court's going to be shown part of it, it might as well be shown the other bit. So,
yes.
Yes. So Sadiqa
is your principal submission.
Yes,
it's
so
not.
It's not binding.
Well, not binding, but
So,
is it
so
authoritative?
No. In Sadiqa, one of the parties suggested that it could be used like a textbook. The Secretary of State's answer to that is, well, textbook's a bit more neutral than the unilateral position of one party. So, although Sadiqa says the party suggested, in fact the Secretary of State didn't suggest it. It's not really even on all fours with the textbook. It's not even the official position of the Commission. So we say it doesn't have any particular weight, but the court ought to see if it's going to see a bit of it, all of it.
I think in the context of treaty interpretation, there is some other authority on that one party's own published position is not a proper aid to interpretation. And we are in Vienna Convention.
Yes, that's right, my lady.
Is it commonly cited in these cases, Ms. Smythe?
It is, with the caveat that I've just given. It often appears sometimes as a way just to be helpful to show court practicalities, to show the court what the Commission has said. It does seem to crop up quite a lot. Our position is often, or sometimes at least, the Commission is wrong in it. I might as well turn up and say, well, but the UK says it means this. Can you read this? Having said that...
when you do it, that's what your case is.
Well, well, no, that's me making submissions.
Exactly.
I'm not pulling out.
No.
I'm not pulling out the Secretary of State's guidance and saying, well, this is a helpful guide to interpretation. I'm making submissions about. It's
the point my lady makes is quite important, isn't it? It's not like guidance issued by a government for the interpretation of a domestic statute. It's a guidance issued by one side to a treaty.
Yes. Well, in that case, we can leave it alone. But could I just ask the court to know?
Well, I'm just curious about
what it says. Well,
in a way.
Yes.
We got to go, shouldn't we?
Okay. There we are. So it's tab 81, page 1842. No, there is no page 1842.
No, it's right at the back, isn't it?
It's page one. I don't know how I got that. It's
61.
Tab 61. Page 1482. Sorry, 1481. And it's the bit under 2.8.2.
Right, 2.82.
2.8.2.
2.8. Conduct before and after.
Yes.
Well, that's pretty clean the other way.
Yes, exactly. So at least on that point, it agrees with the Secretary of State's position. The only qualification that it adds is the slightly equivocal one that Mr. Hickman showed the court, which is in relation to Article 21, which says restriction decisions taken in accordance with national legislation must comply also with the principle of proportionality and fundamental rights, such as the right to family life. Well, the principle of proportionality and fundamental rights, not the principles of proportionality and fundamental rights, such as the right to family life. So, Commission could well be saying all that's left is what I showed the court.
ECHR.
Exactly, which I showed the court in cases like Sakaridis, and so it doesn't. And the court will have seen we've got a respondent's notice in Molnar, and we've made the submission in Vargova that if we're wrong about everything else and the proportionality principle applies, it's no more than ECHR, and so there's no breach of the withdrawal agreement because it happens anyway. So the $1 million question then, because we say that there's nothing in the submission that's been made about grounds and safeguards, is the point that the court made, which is, does Article 21, via the inclusion of, in effect, Article 31.3 of the directive, undermine or somehow qualify what we say is the clear effect of Article 20 sub 2? And we say no, Article 21 does not have that effect. So the first point I ask the court to bear in mind when considering this question is recitals 22 to 25 of the directive and the conceptual distinction that the directive draws between the circumstances in which you can deport somebody on the one hand and the procedural safeguards on the other. That distinction, we say, is embedded in the directive and therefore can be assumed at least to have guided what was in the minds of the UK and the EU when they put in Article 20 and Article 21, that they're doing two different things.
So which recital did you say again was that?
In the directive, it's 22 to 25.
Right, yes. Yes, that's right, where we were at it. Yep, thank you.
Now, I've already made the point that Article 21 is a general provision which applies in a broad range of circumstances, and that's addressed for the court's note in paragraph 62 of our skeleton. And I've also made the point that because it is a general provision which covers a broad range of circumstances, and because Article 20 sub 2 is a specific provision, it is Article 21 which comes in behind Article 20. In other words, Article 21 does not override Article 20 sub 2, and nor does it qualify it. What it certainly can't do, and if you read it literally without, for example, the reference to it being about procedural safeguards in Article 20 sub 3, if you read it literally, it basically means that Article 20 sub 2 might as well not be there. Because if you read it literally, the safeguards set out in Chapter 6 of Directive 2004/38 shall apply in respect of any decision.
Yes.
But that, we say, is not a rational interpretation, and it's not giving effect to the common intention of the parties, because it basically knocks Article 20 sub 2 out, and that is a very clear expression of the intention of the parties, and indeed accepted by both.
Does it do that if you insert the word procedural before safeguards? If you narrow safeguards just to procedural?
No, it doesn't. It works. It works if you treat it as procedural safeguards. In other words, Article 20, what Article 20 sub 3 says it is, then it makes quite clear it's doing what the directive did. Here, when can you deport someone? What are the constraints on you when you want to deport somebody? And I try not to use my hands, but for this I feel I have to. Circumstances in which somebody can be deported, here, all the protections in Article 27 and 28, here, and what are the means by which you test that? And that comes, we say, clearly if one reads Articles 22 to 25.
Well, there's another sort of Latin maxim about construction, which is basically a general provision can't detract from a
Exactly.
specific.
The general
provision.
gives way to the specific, exactly. So we say what it brings back are the procedural protections, i.e. fundamentally the redress procedures which ensure that the state has complied with the constraints or the conditions, as the ECJ put it, which apply to it when it's taking action on conduct grounds. Now, I'll deal with Centulia in a moment, but one important thing to say about Centulia is, despite the fact that Article 15 applies Article 31.3 by analogy, what the court says in Centulia, and recall that Article 31.3 expressly applies Article 28.
Yes.
Court says in Centulia, well, she doesn't get the benefit of Article 28. So Centulia helps the Secretary of State, and I'll take the court back to it, in showing that simply because Article 31.3 says something doesn't mean that you get it, because of the point that my lady Elisabeth Laing made earlier, which is that the procedural right follows the substantive right. There is another example of that we cite in our skeleton, a case called Banger, which is a case about the procedural rights enjoyed by extended family members, and there we've dealt with it in our skeleton at paragraph 67. There, the court, when examining what the procedural right is, effectively looks at the nature of the underpinning substantive right that extended family members enjoy.
Which paragraph did you cite that?
Of the skeleton, or of our...
Skeleton.
The skeleton was paragraph 67.
Thank you. Okay. Yes.
But Centulia is also an example of that happening.
Yeah.
And I'll come back to Centulia. So the issue then is, does the proportionality principle come back in via Article 31.3 of the directive as applied by Article 21, which is an issue that the court raised? And we say no for two key reasons. One, it's not a procedural safeguard. And two, because it's inconceivable that if the UK and the EU intended that the proportionality principle should come back to a national legislation decision, that it wouldn't have told us how it should all work, and left courts like this court scratching its head thinking, well, how does that work because of this, this and this? They would have told us if that's what they'd intended. So then, to just develop those points, my first point was it's not a procedural safeguard, and I think this has already come out in questions and submissions and so on. But fundamentally our point is that the proportionality principle constrains the circumstances in which a member state can deport someone, and it gives rise to then all the protections that we see in Articles 27 and 28.
All right, so just pause. Yes.
And as my lady pointed out, when one looks at what the recitals think the proportionality principle is doing, I think it was recital 23 or 24, it's very much seen as a circumstance or a substantive protection rather than a safeguard. And that's the point that we've already made, or I've certainly already made, which is it can apply as a procedural safeguard, but only if you've got the right to a proportionality consideration in the first place. But of itself, it's plainly a substantive constraint. We saw from the cases where the CJU goes through all of those Article 27 and Article 28 conditions, it's looking at, can the member state deport this person? What are the things that stop them from deporting them? And all of those things flow ultimately from the proportionality principle. So it is... And there's a danger in using words like substantive or whatever, but I've got to use some words. I can't mime it, and substantive seems to me as good a word as any. We've seen the directive use circumstance. We've seen the CJ use the word condition. But
well, you didn't. You chose the phrase confirms the circumstances.
Yes.
That wasn't the verb you used. I can't read my writing.
Constrains.
Constrains the circumstances
in which the member states can deport somebody. And the proportionality principle is effectively the grandfather, and from that all the other protections flow. So basically, on our first point about it's not a procedural safeguard, we say that what you can argue on appeal effectively depends on the scope and the nature of the right which you enjoy. The second point we make, and it might be helpful to stick a finger in Article 21, at the same point look back at Article 31.3 of the directive, which I accept is a procedural safeguard in the directive. The directive tab 22.
Sorry, what do you accept as a procedural safeguard?
Article 31 of the directive.
Okay.
So
you want us to look at 31 of the directive and
so finger in Article
21 of the...
Yeah, so page 237, tab 22.
Funnily enough, it is headed procedural safeguards.
Yes, exactly. And 20 sub 3 follows that by referring to 21 as procedural safeguards. So Article 31.3, the redress procedures shall allow for an examination of the legality of the decision as well as the facts and circumstances on which the proposed measure is based. They shall ensure that the decision is not disproportionate, particularly in view of the requirements, plural, laid down in Article 28. So I made the point earlier that Article 28 isn't only Article 28.1, it's also Article 28.2 and 28.3. So if Article 31.3 brings back proportionality, in our submission, why does it not bring back Article 27 and all of Article 28? Because Article 27, I've shown the court, is inspired by the proportionality principle, and Article 28, similarly, is a manifestation of the proportionality principle. But if that's right, if you read that literally, then we might as well not have Article 20 sub 2. So what we say is that that essentially brings in everything, which means that Article 20 sub 2 is pointless. The much more rational and sensible interpretation is, because Article 21 is a general provision, and it also covers, just let me remind the court, it also covers people who've committed pre-transition period conduct and other people in terms of procedural safeguards, then, but what it doesn't do is give you extra protections if you don't already enjoy them by virtue of Article 20. Now, looking again at Article 31.3, the obvious and big question, and we've asked this throughout, and we asked it in our skeleton, and we submit there still hasn't been a satisfactory answer. If proportionality comes back in, how does it come back in? First, because we've shown that it really inspires all the Chapter 6 protections, so how do you strip something out? What do you strip out? And as we've submitted, why stop? Article 28.1 has been put in the frame, but Article 31.3 refers to all the requirements in Article 28. So no reason to just say Article 28.1 applies. There's nothing we submit in the Withdrawal Agreement or the wider EU law background to suggest that what that must mean is that you bring in Article 28.1 only in this context. It's simply not there. So what you end up doing, if you apply Article 31.3 to giving new protections that don't exist under national legislation, is you totally undermine Article 20 sub 2. The other point that we've made is,
why does taking into account the whole of 31 undermine 22?
Because Article 31.3 says ensure that the decision is not disproportionate, particularly in view of the requirements laid down in Article 28. So at least brings back all of the protections in Article 28, including the serious grounds and imperative grounds test, but it also brings back proportionality. But again, nobody's really explained, we submit, how that would actually work. Is it the bare Lumsden proportionality principle? But in that case, the legitimate interest is that behind the 2007 Act. Is it the proportionality principle as given effect by the directive? Well, that brings back all of the protections we submit in Articles 27 and 28. And Article 22 is really saying, well, you don't get those anymore. You get national legislation applies. So it has to be construed sensibly as a whole. So the procedural protections you get by virtue of Article 21 reflect the actual rights that you enjoy, or put differently, the constraints on the member state in terms of the circumstances in which it's entitled to deport you. And we do say that if one steps back on our construction, it all works together. On the appellant's construction, the UK and the EU have left in a complete confusion the question of how any of this can work in circumstances where Article 20 sub 2 says very clearly that national legislation applies. And we say, in fact, we rely on the fact that they have come up with different interpretations over time, and a distinction between grounds and safeguards, which is unprincipled as a matter of EU law. We say that rather proves our point, whereas our construction, all the bits hang together and it makes sense. And our alternative position, as I've said, is if anything can come back in compatibly with Article 20 sub 2, it's family life and private life. But as I've said, that's what's done in any event under the domestic rules at stage 2. So there can't be a withdrawal agreement breach for that reason in addition. So I need then to deal with Centulia. Yes. Which is at tab 56.
Just thinking about how you're doing.
I'm doing okay.
You're going to take us to Fir Tree as well, are you?
That I don't need to take the court to Fir Tree. I need to deal with AT. So I've got Centulia, I've got to deal with reference, and I've got to deal with AT.
Okay.
And then I've got to deal with where we've got to in terms of what happens next.
Okay. So that feels as though it should be finished by 3:30.
It does.
Yes.
And it will. It doesn't just feel like it, or as close to it as possible. So
sure.
Centulia at tab 56. So it's useful, again, to start at page 1377 with a reminder of what Article 15 of the directive said.
Yes.
So the procedures provided for by Articles 30 and 31 should apply by analogy to all decisions restricting free movement of union citizens and their family members on grounds other than public policy, public security or public health. Now, what Ireland is saying in this case is, look, this was somebody who was residing in accordance with EU law, but she's not anymore. So when we want to remove her, we don't need to worry about EU law at all. We can just use our national legislation. And there's a just for the court to note that argument is briefly captured at paragraph 32 of the Advocate General's opinion, that's what Ireland was saying. So the question for the court really is, well, is Ireland right? Can it just apply its national legislation, or is there some kind of constraint, EU law constraint, on its ability to deport Miss Centulia, who legitimately lived in Ireland but has now broken up from her husband and doesn't have any right to reside? So that's really what the case is about. Now, before I highlight a couple of features of the case, I just want to address what we say are three core and crucial differences from the situation that this court is addressing. So the first is, as I've said, Ireland argued that its domestic legislation applies, but unlike in this case where we've got a provision which says national legislation applies, the directive didn't say that national legislation applied in those circumstances. It was silent on it, albeit that Article 15 was there. So although Ireland was saying national legislation applied, it didn't really have anything to base that on. It was just saying, well, the directive, there is Article 15, but because she stopped residing under EU law, we can just use our national legislation and EU law's got nothing to do with it. But it didn't have what we have here, which is a provision saying national legislation applies. So that's the first crucial difference. Second, and connectedly, Miss Cianciullia was not a person who'd committed crimes after the end of the transition period, which is what this case is about. The third point is that her case was decided when EU law applied, and given that the directive didn't address the circumstances in which it certainly didn't say in this situation you're outside EU law. What the court could have done is simply said, well, EU law still applies. She did start off with a right to reside, and so Ireland's required to apply the proportionality principle before it removes her for that reason. What that, of course, doesn't say is what happens when you have a specific provision which says national legislation applies. So it really doesn't help the other side. What it does help, and this is relevant to this case, is that it establishes that just because Article 31.3 says that things apply, doesn't mean they actually do apply if they're inapposite for your case. So just to show the court then, it's paragraph 86.
Which follows up Mr. Hickman's starred paragraph 85.
Yes. What it says is that she doesn't get the benefit of Article 28. So it doesn't really tell us what proportionality is going to get her, but it certainly doesn't get her the Article 28.1 considerations, because 86 says other provisions of Chapter 6, including Articles 27 and 28, are not applicable. Now, bear in mind, of course, that bits of Article 28.1 could have been applicable because they refer to things like length of residence, personal circumstances, but the court says that doesn't apply. And that's notwithstanding the fact that Article 31.3 expressly referred to it. So for all of those reasons, we say Cianciullia helps the Secretary of State.
Is Article 87 relevant?
Article 87.
Oh, paragraph 87.
Paragraph 87. Sorry.
Not particularly. For our purposes, it's the key point is the inapplicability of Article 28. So what we draw from that is, just because Article 21 of the Withdrawal Agreement says the procedural safeguards, as we interpret it, in Chapter 6 apply, that takes you to Article 31, but it doesn't mean you get the full protections described in Article 31.3 if you don't enjoy those rights as a matter of substance in the first place. So moving then, that completes my 5 topics, and I've made my submissions as I've gone along. What I was going to do is just deal with mop-ups now. So AT, first of all, that there have been some general submissions made in relation to the case of AT. It's important that this court knows this, that it needs to be, AT needs to be understood in light of the very specific issue it decided. And that turned on a CJ EU judgment called CG. Now, there was extensive argument on AT before this court in the Fertray case, and in particular, Mr. Cox sought to rely on it in that case to say that anybody who had pre-settled status was residing on the basis of the directive and therefore was entitled to equal treatment, and that argument failed in Fertray. So the court, I don't think this, in fairness to him, it's certainly not what Mr. Hickman said, but it is right just to be clear about, well, what is this Article 21 right that AT talks about? So could I just first of all ask the court to look at Fertray, which is at tab 45 of the bundle. This judgment was handed down on the 31st of July of this year.
Yes.
So first of all, could I just invite the court to read paragraphs 88 to 89, which is the rejection of Mr. Cox's reliance on AT in that particular case. And it sums up what AT was about. There's then a further discussion at paragraphs 128 to 132. Now, I was in this case. Essentially what happened was the IMA and the Secretary of State agreed with one another that Mr. Cox's submission was wrong, but there was then a debate as to the extent to which the reference to Article 21 of the treaty in Article 13 of the Withdrawal Agreement could itself give rise to a right of residence. Now, it's impossible in the time we have now, and certainly given the issues in this case, to convey to the court the complexities of the decision in CG and the decision in AT, which is based on it. But I can say this much. CG was a case fundamentally before the end of the transition period about whether somebody who had pre-settled status but who wasn't residing in accordance with the conditions in the directive enjoyed a right to equal treatment. And the ECJ said, no, they don't. But it then added that there was an obligation on states to apply the Charter in that situation. And the way that it did that was essentially to say that although the person isn't residing in accordance with Article 21, they effectively, Article 21 is a trigger for the application of the Charter. It's quite complicated reasoning, and we went back and forth over it in Fertray. The debate essentially is Article 21 a residence right, or is it simply a triggering right for application of the Charter? And what the Secretary of State says AT is doing is saying Article 21 is a triggering right for application of the Charter. That gives you the background then to the issue that's addressed at paragraphs 128 to 132 of Fertray, which is, well, does it do something more? So, could I invite the court to read those paragraphs?
128 to 130.
Yeah, 128 to 132.
Yes.
I think this part of the argument was more Shelter's than Mr. Cox's, in fairness. So the key passage is really 131 to 132.
Yes.
Now, probably what it's fair to say is that this is all monumentally complicated. This court doesn't have to decide the point. So my central submission really is one needs to be cautious about saying anything about Article 21 in the Withdrawal Agreement and what its effect is.
Sorry, Article
21. Article 21 of the treaty.
Exactly.
And
the
its
TFEU.
effect. Yes, sorry, and its effect within Article 13. But I wasn't fully clear as to the point Mr. Hickman was making. That is me, not him. But I just sound this note of caution. What I do want to show the court in AT, and I've lost it, but somebody give me the tab for AT. They don't mind.
I think it's 40.
Thank you. AT is a complex decision, but it's basically getting to grips with what the ECJ had decided in a case called CG. And essentially what it's deciding is, does AT benefit from the Charter of Fundamental Rights in order to assert a right to benefits? And the debate about Article 21 is all about deciding whether application of the Charter is triggered. But importantly, what the court said at paragraph 103 is that doesn't mean that all of the provisions of the Charter, and this is on page 715, come back in. One of the points that the Secretary of State had made was that the Charter includes things like the right to vote, and that has now gone after the end of the transition period, because UK nationals can't assert EU citizenship rights to vote in other member states. That's gone. And what the court confirms is that the Charter isn't brought fully back into play. Where the absence from the Withdrawal Agreement of any right to vote meant the Charter had no application to assist a UK resident in France who wished to vote in local elections. The Charter only applies if and insofar as it can attach to rights brought into domestic law by the implementation of the Withdrawal Agreement. So the point we make is, similarly, if in a deportation situation you have a direct provision in the Withdrawal Agreement which says that national legislation applies, what you can't do is bring back you can't bring back principles of EU law to undermine that. The other point to make is this, that there is, I think, a suggestion that AT decides that individualised assessment is a general principle of EU law. That's not right. What it decides is that AT was entitled to benefit from Article 1 of the Charter, and that Article 1 of the Charter required an individualised assessment to be conducted. And for that...
Can we look at that?
Yes. If the court looks at 117, without having to read all of the decisions, that is apparent simply from a description of the issues in the case. So the issues arising, paragraph 117, this part of the judgment is after the court has decided that the Charter applies. So point A, the Secretary of State said, well, if there is a duty to protect fundamental rights, that's satisfied by the framework, the statutory framework, and or by section 17, that's B. And then there was an issue that the court had to decide whether that was good enough, or in fact, did there need to be an individualised assessment of an individual's need? And the answer that the Court of Appeal gave is yes, the Charter requires an individualised assessment. It isn't good enough to simply say, well, we've got fallback protections generally in our domestic law. But it's wrong to say that there's some general principle of individualised assessment. So far as the Charter is concerned, in this case, the only provision which is capable of being engaged, we submit, in terms of the substantive protection against deportation is Article 7 of the Charter, and that is coextensive with Article 8 of the ECHR. As I said, Mr. Hickman took you to passages about assumptions. This is not a situation here where the Secretary of State's relying on assumptions. The Secretary of State's relying on the clear wording of Article 20 sub 2. What she has done to counter the suggestion that it can't be right because it would allow very minor offences to result in somebody being deported is explained that it makes sense that the UK and EU would say, well, if you commit crimes after the UK has left, national legislation applies. And similarly, if I had rights in Germany and I were in Germany, and decided to commit a crime on the 1st of January 2022, I would have to be subject to German legislation. So that is AT. That just leaves the reference issue, and I can take this briefly. It won't surprise the court to hear that we say the meaning is clear, no need for reference. The one point I would make about Article 158 of the Withdrawal Agreement is that under Article 267 of the treaty, there was an obligation for a court or tribunal against whose decisions there was no judicial remedy to refer. There was an obligation under the old system. That's gone. It's now a discretion, even for the Supreme Court. And we had some debate about this recently in the Supreme Court, but they haven't decided the point. So there isn't any authority. But essentially, Article 1...
Has it decided because they haven't decided, or haven't decided yet?
They haven't decided it because they said they didn't need to, because it was clear. But one of the points that the Secretary of State made there and makes here is, if the contracting parties had intended to impose an obligation to refer, they would have used the language of Article 267 of the treaty and not the discretionary ability to refer. So we don't accept that actually there's a greater imperative to refer now. In fact, the Withdrawal Agreement says, well, no, it's actually just a discretion. And the final point we make is that there's no problem with different states applying their national legislation because the Withdrawal Agreement expressly permits it. I mean, I accept that's part of my point that the meaning is clear, but that's where we are. And I've made my point about it doesn't really help the point to say now any minor infringement can end up with somebody being deported, because that's not really in accordance with reality and what everybody knew when they sat down to negotiate the Withdrawal Agreement. That just leaves where we are in terms of, depending on what this court decides, how we sort things out. Mr. Cox said if he loses that the Secretary of State was trying to vary the upper tribunal's order. We're not. So that's the end of that. I think he thought that because what we've said is it's a bit odd, if we're right, for the Regulation 6 appeal to be remitted, because there's not really anything to argue about, but we've got no problem with it being remitted. We've said that in Vargova, but if my learned friends lose and the decision of the upper tribunal stands, if on the other hand one or more of the arguments is successful from the appellants, then assuming that there's a material error, the relevant decisions of the upper tribunal fall to be set aside. But at that point, the Court of Appeal then stands in the shoes of the upper tribunal. So it will be for this court to decide what to do. It wouldn't be that the first tier decisions automatically revive. And we would certainly say, if one takes, for example, the Vargova first tier decision, where the tribunal certainly directs itself that all of the Chapter 6 protections apply, it wouldn't be right for that decision to revive. But in our submission, depending on the decision of this court, and assuming it isn't clear as to what the court should do, the court may want submissions from the parties at that stage.
In the event that the appeal succeed?
In the event that, yes, because what needs to happen next will rather be affected by how this court decides it.
Yes.
Yes.
Thank you.
Could I just turn my back for a moment?
Anything else, Elisabeth?
I was asked, are there any references in other articles of the withdrawal agreement to Article 21? And it seems that I've managed to find them. It was Article 18(3) and 20 sub 3.
Yes, thank you very much.
Does the court have any more
We
questions
don't.
for me?
Thank you very much, Ms. Smythe. Mr. Hickman.
My Lord, if I may follow the order of submissions that we've just heard, rather than doing them in the manner that I did them originally. So I'll deal first with ground 1 and then with ground 2. Starting then with the issue about whether there's a restriction on rights. There is something a little, if I may say so, otherworldly about the debate over whether there's been a restriction of a right, particularly in circumstances where my client was subject to a decision to deport her, and was told in the letter, as we've seen, that if she said nothing, she would be deported as soon as reasonably practicable, without any further ado, and indeed under the legal regime without any further decision other than simply a timing decision. Secondly, given that it resulted in her being liable to detention, and she was actually detained and was bailed. And thirdly, a deportation order has actually been made against her, as I referred to. And finally, she has no other right of appeal other than the one she's exercised to raise a breach of the withdrawal agreement. So we do say there is something very artificial and strange about this whole ground. But stripping away all of the points that you've heard on the domestic legislation, in deciding whether a decision that restricts is one that restricts residence rights, one has to look at the right of residence, Article 13, and behind that into the CRD, which is given effect, AT. And that takes us to the Bouchereau case. Can I just ask you to turn that back up and I'll respond to the points that were made on it by my learned friend? Because you do say this is essentially the beginning and the end of the point. Nothing that my learned friend said with respect really provided an answer to our reliance upon it. Tab 46. And my own friend took you to various parts of the Advocate General's opinion, but nothing there in my submission which really supported her position. I mean, the essential message of this case is that there will be an effect on the rights of residents provided by the CRD. At an early stage, where a decision is made which has legal consequences and which is a necessary step in this case, deportation. But that's not the only point at which there's a decision that's restricting a right. So it's clear that there's a spectrum. There is a temporal period in which your rights are being restricted, or you could have a series of decisions. That's the basic message of this case, because what was said here was, well, all that's happened is the judge has made a recommendation, so you're at too early a stage, and the court said, no, not at too early a stage. This is an appropriate stage to say that there is a measure restricting rights. And if we can just remind ourselves, I mean, the point that was made against me was that the recommendation of the judge said that a deportation order shall be made. Just looking for the part, so I've missed it. But there's a clear analogy with our case, because in our case, it's not even a recommendation, but there is a requirement to make a deportation order when you're within Section 32 of the 2007 Act. So we're in a stronger position, if anything, than in this case. Reliance was placed on the fact that there was, in this case, no subsequent tribunal review. It's one of the points the Advocate General made, and you were shown to that passage. But same in our case. The decision is made. If no representations are made, say, as to human rights, there's not going to be any further consideration. There's no tribunal review stage. So there's a measure affecting rights. And if one turns to 21, 22, which are the key, and 23, which are the key passages at page 1046,
yes,
it's very broadly framed. For the purposes of the directive, a measure is any action which affects the rights of persons coming within the field of application of Article 48, which, as I said, that's Article 21 now, TFEU. Within the context of the procedure laid down by 3.6 of the Immigration Act, the recommendation referred to in that question raised by National constitutes a necessary step in the process at arriving at any decision to make a deportation order, and a necessary prerequisite for such decision. Well, it's a fortiori under the 2007 Act, because once you are a foreign criminal, there is a mandatory requirement in law to make a deportation order. Now, of course, there is a mechanism by which that order may yet not be made if a person can bring themselves within an exception. That doesn't necessarily have to happen, and the deportation order will be made. So in my submission, we're squarely within Bouchereau, and if there is a decision that affects CRD rights, you have to read Article 21 in a consistent way, because obviously the two are supposed to march in harmony with each other. And the restriction on rights is a very general term. Decision to restrict rights is a very general term which is intended to embrace all of the measures or circumstances in which there might be a breach of a CRD right, and it's worth reminding ourselves, if you turn up the CRD and reminding ourselves in terms of Article 28, which provides a right that applies before the taking of an expulsion decision. So not just before expulsion, but before taking an expulsion decision. So if you haven't, as it were, acquired that information before taking your decision, there's a breach of Article 28. So it's very clear in my submission that a decision that affects rights, which would be a decision to restrict rights under Article 21, includes decisions that are taken quite far up the chain. As long as they are a necessary step, they are sufficient to come within Article 21. And as I said, the reality of the situation is surely obvious. My client has and was exercising a right to reside under the Withdrawal Agreement and received a letter saying decision's been made to deport her, and if she doesn't do anything, she will be deported very soon. And that is clearly, in substance, if that's the way we're looking at it, as my own friend said, a decision that restricts rights under the Withdrawal Agreement. The Secretary of State, of course, has some discretion about how to structure an appeal and where specifically to locate it in terms of domestic arrangements. But that doesn't affect the basic principle which I've just articulated. Notwithstanding that, we don't accept that this stage 1, stage 2 analysis works, because in our particular case, there may never be a stage 2, for the reasons I've explained. Nor did the Secretary of State identify any legal difference between stage 1 and stage 2. It's purely a matter of practice and substance. Well, this is when we allow representations to be made, we sort of in practice we've reached more of a final position. But there's no legal difference. In fact, my own friend described both stages as decisions to make deportation orders. Legally, both the same decision, form of decision. And can I just make one point clear that's not said against me, that it's a deportation order which brings to an end the right to reside. So you've been shown Section 5 of the Immigration Act. It says when a deportation is made, that's when your right to your leave to remain is terminated formally as a matter of domestic law. But it's not said that that's relevant, and that's right, because in fact the way it works is that is suspended. So the invalidation of your leave to remain is in practice suspended, pending all sorts of appeals. So my client's leave to remain is still suspended. So that's not being relied on, but just in case, because you've been shown that provision and it may.
Okay, thank you.
So let me then turn to round 2.
Yeah.
And the most important point here is that my learned friend has not distinguished the Cianciullia case. And I will explain why. My learned friend says there are 3 core differences. The first one was that the directive did not say that national legislation applied to the deportation of Ms. Cianciullia. But that doesn't help my learned friend, because it was common ground in Cianciullia that national legislation applied, and it was common ground that she had no rights under the residence right under the CRD had come to an end. So that's why it's a good analogy for me, but it's not a ground of distinction. Secondly, it was said Ms. Cianciullia had not committed crimes. It's completely irrelevant, and there was no attempt made to explain why that's a core difference. Thirdly, it said it was decided when EU law applied. Again, that is irrelevant, because Article 15 and Chapter 6, which includes Article 31, are expressly applied by Article 21. So we're in a situation where provisions of EU law are expressly applied by the Withdrawal Agreement. So the same provision that was being applied in Centulia, Article 31, we know, and is common ground, that it applies in our case. So the fact that that was a situation where EU law applied and we're under the Withdrawal Agreement, again, is not a ground of distinction. And then the point was made in an attempt to say that you can somehow ignore what paragraph 30.3 says, that this was a case, Centulia was a case, where they didn't...
31.3.
31.3, sorry, yes, 31.3. Because they didn't apply Article 28.
Yes.
But I'm afraid that doesn't make any sense whatsoever. And perhaps I can just ask you to turn back up Centulia.
Tab 56.
56.
Page 137. 1387.
Yes.
Is if you want.
Yes.
Paragraph 85 and 86.
That's right, my lord, that's right. Familiar to us. But the key point here is that this was a case where Article 31 was applied because it came in through Article 15. And we know, because we've looked at it many times, that Article 15 applies where decisions are not taken on grounds. So Article 28 was not applicable in her case. So there was simply no basis for it at all. So it wasn't a case where there was some sort of picking and choosing of parts of the CRD. It was simply just applying it straightforwardly.
Can we just go back to the first point of distinction, which you said? Well, the answer to that is that it was common ground in Centulia that national legislation applied. I think the point being made was that on our facts, it's specifically provided in the Withdrawal Agreement that national legislation applies.
Yes.
So that was the point that was being made. It's a rather different point.
Well, is it though? Because what that means is, it's not. We've got to be very careful about this national legislation applies because it seems that the Secretary of State would like it if people under the Withdrawal Agreement who commit post-TCD conduct, as defined by, are simply completely outside. And national legislation just applies to them, and the Withdrawal Agreement doesn't apply to them. That's not the case.
That's what we're having a discussion
well, what the Withdrawal Agreement clearly says is that the grounds on which a restriction of rights can be placed is based in national legislation. That is not at all the same thing as saying their situation is governed by national legislation. It just says the grounds can be set out. So whereas we have a very limited set of grounds under Article 27 and 28 on which you can rely on conduct to restrict the rights of people protected by the CRD, EU citizens, that we can have a wider set of grounds because you can choose which grounds you want. So you don't have to have imperative grounds of national security or state security or whatever. You can have different grounds, but that's all it's saying. It's not telling you anything about, in general, about the application of principles such as proportionality. Now, in this case, it's quite clear that they did not. The key point is they didn't have to rely on the grounds in Article 27 and 28 in order to deport Ms. Centulia, because those grounds didn't apply to her because she no longer was exercising rights under the directive. So they could rely on their own national grounds. So it is the same scenario as we're in here, or at least materially the same. The only way it's different is if you sort of read the reference to grounds based on national legislation very broadly as to sort of exclude proportionality. The problem with that is it's subject to Article 21, which brings in procedural protections, and Centulia tells you that includes 31.3, which includes proportionality.
Okay, so to make sure I understand that, you say we're back into 28 in this case because it is a matter of public policy.
Yes.
whereas in Chinchulia it wasn't.
Yeah.
So could national legislation be brought in to which Article 20.2 applies, which is a ground that you couldn't describe as public policy, and in that situation you wouldn't go back to Article 28?
In that situation
correct?
you'll be in Article 15, so you'll still end up in Article 31. You can't escape Article 31 or Article 30. But you don't necessarily get 27 to 28.1. That depends on whether the conduct is properly described as being public policy and so forth. But so those grounds of distinction don't, with respect, work at all. And Chinchulia, on any view, tells you what the procedural safeguards in Article 31 are, because if you look again at 71, there's a reference to Article 15 of the directive, reference to the heading procedural safeguards, provides in paragraph 1 that the procedures provided for in Articles 30 and 31 are to apply by analogy. To all
I'm so
decisions.
sorry, where are you reading from?
Paragraph 71.
71, thank you.
1385.
So it's very clear that they're focusing on the procedural safeguards. Okay? So, and the procedural safeguards is therefore a concept of EU law, which we know under Article 4 you're bound to follow the interpretation of those concepts given by the CJEU. And you see at 73 why 27, 28 don't apply, because it's grounds wholly unrelated to danger to public policy, public safety, public health, etc. Yeah, so it's grounds wholly unrelated to any of those. Emphasise grounds.
Where are you reading?
That's 73. According to the very wording of Article 15, and on pain of depriving that provision of a large part of its substance and practical effect, the scope of Article 15 must extend to an expulsion decision made, as in the main proceedings, on grounds wholly unrelated to any danger to public policy, public safety, as was in Mr. Chinchulia's case. So, pausing there, and wasn't the point I was going to make, but you can see how the notion of grounds is an EU law concept, and you can see how you can have grounds that are not related to public policy, public safety, public health. Chinchulia is an example of it. So Chinchulia is an example of something that a state can do. So the UK could do this if it could be related to conduct. I'm not sure her case, you could say it was conduct, but it's conduct, it can be wholly unrelated to public policy, public security, so forth. So anyway, they're applying the procedural protections, and you trace that through to 86, as Article 15.1 of the directive refers only to the application by analogy of the provisions in Article 30 and 31 of that directive, other provisions of Chapter 6, 27, 28 are not applicable where the decision is adopted under 15. So there's no problem with that. It's not a picking and choosing. It's just simply applying the directive. But it's very clear that the court finds, as we've seen, that the procedural safeguards include proportionality. And indeed require redress procedures which involve consideration of the facts and circumstances on which the particular decision is based. And that's 85. And in my submission, there's just no attempt, no plausible grounds for distinguishing the impact of that decision on the question that's before this court. Now, the Secretary of State's argued that 27.1 28.2 are, sorry, 27.2, 28.1
Yeah.
are emanations of the proportionality principle.
Yes.
The way it's put is they're inspired by the proportionality principle, and therefore cannot be applied because proportionality can't be applied. There are a number of difficulties with this reasoning. First of all, Article 20.2, most fundamentally, does not say the proportionality principle shall not be applied.
Sorry, 20.2.
20.2. It says that the grounds based on national legislation. But you can have the grounds based on national legislation and still apply the proportionality principle. They're not inconsistent. That's one of the things you get from Chinchilla. Secondly, even if Articles 27 and 28 are to an extent inspired by the proportionality principle, that is unsurprising because the proportionality principle is a fundamental principle of EU law which conditions all EU instruments and laws. And it runs clearly through the design of all legislation. In certain specific contexts, such as expulsion, as we've been seeing, CJEU case law is crystallised into legislative instruments, and that's what's happened with the CRD. And that legislative instrument refers to certain, in certain paragraphs, refers to grounds, uses that term. It's not a coincidence that the same term is used in Article 20.1 and 20.2. It is a clear and obvious express reference back to the design of the CRD. So even if those paragraphs that set out grounds may have historically had their inspiration in part in a principle of proportionality, it doesn't matter because the withdrawal agreement has been drafted by people who are familiar with the CRD and the language of the CRD, and they've used that language to try and identify to what extent states are free to legislate in relation to conduct that post-dates IP completion date. And they've clearly linked it to grounds. And they have not said anything about proportionality. But what they have done is said that safeguards under Article 15, Chapter 6 come in. So what that means is all the safeguards come in except for the grounds. Now it may be something of a less than straightforward task in a particular context to go through and identify, is this a ground? And if this is a ground, it's okay, if it's not. But that doesn't mean it's not required by the withdrawal agreement. My learned friend says, well, you know, you should try and interpret it clearly because that's going to mean that there's less trouble in terms of the withdrawal because the withdrawal.
Well, what she said was that was consistent with the objective. I mean, I'm paraphrasing what she said.
Well,
that's clear from the recital.
Well, in my submission, it's not, and in my submission, that in fact, one has to take into account the fact that this is negotiated in the hurly-burly. There's going to be redundancies. There's inevitably going to be things that have to be worked out by the courts.
Well, Miss Smythe emphasised the recitals as being defining the context. Hurly-burly doesn't appear in the recitals. Whatever may have happened in the negotiations.
No, but it is mentioned in a judgment of this court, very recent pedigree, and in relation to the interpretation of the agreement. But if one looks at the recitals, in my submission really isn't anything there anyway, which assists my learned friend, and if anything, they assist me, perhaps we'll just have a quick look at them.
Page 135A.
136. Oh, sorry, 135A. It's from Molnar.
Orderly withdrawal in the stressing.
But that orderly withdrawal does not authorise this court to, as it were, try and interpret the agreement or rewrite the terms of the agreement in a way which is clearer. That's not what that is getting at.
Well, that's what Miss Smythe was proposing.
Yeah, well, my submission, that's not what that is getting at. But whereas if you look at the next paragraph, recognising it's necessary to provide reciprocal protection for EU citizens and for United Kingdom nationals, as well as their respective family members and so forth, what protections would they be getting? Because you could have national legislation, as I've started by saying, you could have legislation in Hungary, you could have it in France, you could have it in the United Kingdom, wherever, which took away the rights to reside, people with withdrawal agreement rights, on the basis of very trivial conduct. Doesn't have to be criminal. My learned friend kept saying, well, they have no rights if they're going to commit crimes. And that was the intention. That's not what the agreement says. It's not what the agreement says. And the spectre of trivial conduct or blanket conduct is one that you have to use to test the intention of the agreement. My learned friend says, well, you don't need to worry about that because everyone's signed up to the European Convention on Human Rights and things might change.
Yeah.
Secretary of State says 31.3 reference.
What about the point about legal certainty from recital 7?
Well,
Resolved.
Yeah, that's the last paragraph on the first page.
Well, in my submission, the dominant interpretive principles are those set out in Article 4. And in my submission, they drive you to a result in this case because of the Court of Justice decision in Centulia, which tells you what certain concepts used in the agreement mean. So obviously, legal certainty is a desirable objective, but and I'm not saying that we accept that there's any lack of legal certainty in our interpretation. Of course, one has to engage in that process of working out what is a ground, but it's not, with respect, that difficult. And I can tell you now what we say are the grounds. It's the paragraphs that refer to themselves as grounds. But what is the Secretary of State's case that's so much simpler? Because what are the procedural rights that the Secretary of State says comes in? Well, we were never told in my learned friend submissions. We were never told what those rights are. But it seems that they are simply the right to be informed of the grounds on which your rights are being restricted and an appeal, which is, I respectfully endorse the comments from my lord that they're not really worth very much. Imagine that in my client's case, he's committed an offence. There's a law that says you've committed an offence of more than 12 months imprisonment, you'll be deported. Being told that you fall within that category and having a right to appeal is of no value whatsoever. It's the individualised consideration which is critical. But whether the procedural rights go further than that, we don't know, because we haven't been told what these procedural rights were. But if they are as limited as I've suggested, then that also doesn't match up with the language of Article 20.2, because that talks about safeguards, in the plural, plus an appeal. all you're getting is notified and told you've got an appeal, and that's it. That doesn't meet the plain words of Article 20.2. Now, the Secretary of State says that Article 31.3, reference proportionality, is in fact just saying if you have a proportionality right already under 27 or 28, then your appeal under 31, you can ventilate your proportionality arguments. That's the Secretary of State's position. And therefore the Secretary of State says that 31.3 is, as it were, simply a derivative reference to proportionality, which can be sort of blue penciled out. But that clearly doesn't work. And it clearly doesn't work because the Court of Justice in Centulia tells you it doesn't work. Because in Centulia, there was no right of proportionality other than from 31.3. My own friend said that Article 20.2 does not refer to any union law concepts, and therefore does not bring in Article 4.3. It does. It refers to grounds. It also refers to the right to reside, which, as I've explained, is based on Article 21. And grounds links in, meshes in with the CRD.
Well, grounds in accordance with the national legislation.
Yes, but what is a ground? What that means is you find the grounds that are imposed by EU law, and you don't apply the grounds that are imposed by EU law, because you can impose the grounds chosen by national legislation. So what you have to do is find what national legislatures were restricted to in terms of grounds, and that requires you to look at the CRD and identify the grounds. And although my own friend says, well, this is not a straightforward task, it is the task that is required by Article 20.2.
Doesn't actually say that, though, does it? I mean, sounds like you're reading into what looks like a straightforward provision.
Well, I'm not, my lady, with respect. If you turn it up, it's my learned friend that's reading in, but it's my learned friend that's essentially drawing the inference that proportionality is somehow excluded by 20.1, 20.2 and 21, when there's nothing there which requires proportionality to be excluded. We completely accept that 20.2, by saying, referring to the grounds for restricting the right of residence by host state or the right of entry in accordance with national legislation, means that the grounds under EU law are no longer determinative. That's what it means.
Forgive me, Ms. Tickman. What Miss Smythe asked us to do, in quite a striking, if I may respectfully say so, passage in her submission, was to read Article 21 and 22 together.
Yes.
And on doing that, on her interpretation, which she invites us to adopt, Article 21 requires the whole of the exercise of considering the conduct of union citizens to be conducted under Chapter 6, whereas in cases of post-transition period conduct, that to be considered under national legislation.
Well, no.
I'm probably doing violence to the subtlety of her submission, but the key point is that she it's the contrast between 1 and 2 that she emphasised.
Well, but in my submission, it doesn't take her anywhere far enough, because what 20.1 is saying is yes, in relation to conduct that occurred before completion day, Chapter 6 continues to apply. After completion day, if conduct occurs, on which then you say, well, a restriction can be imposed on rights, on the rights of those individuals, on grounds set out in national legislation. So it's a sort of, it's a limited departure from Chapter 6, because it's saying the grounds for restricting rights in Chapter 6 no longer determinative. You can apply wider grounds under your own national legislation, but then all the protections of Chapter 6 are brought in through Article 21.
Well, okay, your case is in Article 21. And the question is, what are the safeguards?
What are the safeguards? And in my submission, quite
what are the safeguards, and to what extent do they apply to 22?
Well, in my submission, quite a telling concession by my learned friend was that in one sense you can describe the whole of the CRD as a safeguard. Everything's a safeguard. Well, on that analysis, what you're trying to do then is all you're doing is taking out of the application of the CRD the grounds, the limiting grounds under EU law, which restrict your ability to take measures, using the language of Article 27, against people enjoying free movement rights.
I mean, doesn't the issue in this case ultimately come down, again, I apologise, I'm doing violence to the subtleties of the submissions, to whether the safeguards referred to in Article 21 are the narrow procedural safeguards, so-called in the CRD, or extend across the whole of Chapter 6 to embrace the principle of proportionality.
Yes, absolutely, absolutely. And proportionality is not a ground. That's the critical point. And that's my central submission.
Yeah.
And although, so my Lord talks about the narrow procedural safeguards.
Well,
this is where
I preface that by saying, apologies for the violence, if I'm doing violence to the subtleties of your submission.
My submission on this is not a subtle one. The CJEU has decided.
It's 4 o'clock on the second day session.
So the CJEU has decided that procedural safeguards include Article 30.3. They include proportionality. That's not a subtle submission.
Well, that begs the question of whether Article 31.3 does include, to what extent it does include the principle of proportionality, as opposed to, well, the narrow scope which Miss Smythe argues.
But in respect, it doesn't, because what my learned friend says is that proportionality is a derivative to Article 27.28, and it's giving you an appeal right to argue about proportionality if you're already in 27 and 28. But Centulia is a case where 27 and 28 didn't apply. There was no, as it were, restriction on being deported by reference to proportionality that you get from 27 and 28. She didn't have that right. So it's clear from Centulia that proportionality under 31.3 is being used in a freestanding way.
Which particular passage in Centulia do you say demonstrates that?
Well, it's the passages we've been to.
It's 85 that demonstrates.
Yeah, and 86 where they find that 27, 28 are not in play.
But they don't go on to give any guidance about how you apply proportionality.
They don't. No. Proportionality applies all the time in EU law.
This brings us to a point which, yes, you make it.
Yeah, well, it's. I think it's the point that's been discussed throughout. Is what you're ultimately looking to do is to tether the proportionality analysis to things like what's said in 28.1. In particular, length of time, their integration, and so on. That's why I was looking in Chanchulia for any indication of what they mean by proportionality in that particular context.
I don't submit that is there, but in my submission,
So I'm right in thinking there's just the bare statement in 85.
That's it. Yes, that is it. So, but nonetheless,
is it clear?
It gets me home on proportionality.
Well, discuss, yes.
Consider.
There's a respondent's notice point, for example, that says, well, in the context of this case, that means Article 8 only.
Well, in relation to...
Because you've got to look at the national legislation. That's what's at the core of this.
Well, there are differences. I won't repeat the submissions I make. My own friend didn't actually really make submissions on them in response. But you know, I've made my points. That the basic point is they are not the same. They overlap, but they're not the same. ECHR proportionality, EU proportionality. You know, it would not be safe to rest on that premise. You would have to look at particular contexts as they arise. But it is true to say that 28.1 and 27.2, they do introduce these notions of, for example, 28.1, prior consideration before you make an expulsion decision. You've got to take into account these things. So there is a sort of a pure process point there about that you have to go through. You have to consider things that are specified. And that's a sort of pure relevant considerations kind of analysis, to use an administrative law type of analysis. And we do say that gives further colour to the concept of proportionality when you're within that public policy area, so that applies.
Now we've interrupted you a bit, Mr. Hickman. I'm conscious Mr. Cox may want to say a few words.
Yes, I will.
We can't sit after 4:30.
No, we won't need to. Sorry, let me just find my place again, my lord. Apologise. My other answer to this point about proportionality is that it's not as complicated as my friend was making it sound. Look at the first instance decision here. I mean, it's a fairly standard proportionality approach. You look at the facts and circumstances and you take a view. And where the Secretary of State's taken that view beforehand, then there's also case law on, you know, the degree to which a tribunal would give respect to that analysis. So it's not difficult. Our first instance tribunal did it. Just in terms of the tribunal decision, in our case, the tribunal refers to 27.2 in full and 28.1, but it's clear when you look at the proportionality analysis that they're not applied, that they haven't applied the heightened, the serious grounds and so forth. So in my submission, it was a straightforward proportionality analysis, and if you're with me on proportionality, then there would be no need to disturb that decision. I don't propose to say anything else in reply, but if there are other questions.
None from you. No, well, thank you very much. We're very grateful. Thank you. Mr. Cox.
My Lord, I'll follow the same structure, if I may. Ms. Smythe characterised a stage 1 decision as a decision that a person meets the condition in Section 3 of the Immigration Act and is thus liable to be deported, and a stage 2 decision as one that none of the exceptions in the UKBA, or alternatively the discretion under the Section 5 of the Immigration Act, should be applied, and thus is to be deported. Now, in my submission, on that framing, only a stage 2 decision is a decision to make a deportation order. Her stage 1 decision, as I've just framed it, as I've just understood it, is not a decision to make a deportation order. It is merely a decision that a deportation order might be, or that there is power to make a deportation order. That has never been a decision that could bear the label decision to make a deportation order. As is demonstrated from our skeleton, until 2015, the decision to make a deportation order was the occasion for the right of appeal. It would have made no sense for Parliament to confer a right of appeal merely against a liability decision, but not against an actual decision to make a deportation order. Now, however, where the Secretary of State, as here, gives notice of a decision that is headed decision to make a deportation order, that decision in my submission does constitute a decision to make a restriction for the purposes of an appeal under Article 21 of the Withdrawal Agreement. She cannot deny the tribunal's jurisdiction by contending that her decision wasn't in substance a restriction, because it wasn't in substance a decision to make a deportation order, that she hadn't got there yet. If it carries the formal label of a decision to make a deportation order, then it is, under the domestic appeal scheme, my submission, a decision restricting rights.
She's not seeking to deny the jurisdiction.
You're right. I could express it in compressed terms. She's seeking to deny that she's seeking to deny that the tribunal has any power to allow the appeal, because she's saying that the decision is not a restriction on the person's rights under the Withdrawal Agreement. Now, if it's not a restriction on their rights, the appeal can't succeed.
I have addressed that in my submissions with respect. I explained why there is a right of appeal and why the person can assert that there's a breach of their rights.
I understand what Ms. Smythe said, but I still maintain my submission that if she's right that it's not a restriction, you can't complain that it's a breach. But my point is that you can, and that Mr. Molnar was entitled to, and that the First Tier Tribunal made no error of law in deciding that the first decision was a decision to make a restriction and therefore breached his rights because it hadn't involved a proportionality assessment. I think what the court is, in my submission, Ms. Smythe, I think, helpfully explained that the Secretary of State has been issuing these decisions on the premise that they were the occasion for working out which scheme of appeals someone should fall under, and that if a person wished to assert that they in fact have substantive rights under the Withdrawal Agreement, that was the occasion for them to assert it. I think what the Secretary of State has gone wrong is thinking that that is in substance, a decision to make a deportation order. You can see why practically she's used it for those purposes, but the statutory scheme in my submission didn't allow for her to, or isn't intended to allow for her to characterise decisions that the person is liable to be deported as decisions to deport them. And I think that's what happened in Mr. Molnar's case. In relation to ground 2, the proportionality assessment that's required under the Withdrawal Agreement is different from the UK's implementation of Article 8 ECHR proportionality. The Withdrawal Agreement allows for the UK to stipulate new grounds that would not have been permitted under EU law, but it cannot stipulate the approach that the courts or its officers must take to proportionality, such that no weight is given to the rights of residents under the Withdrawal Agreement. That's the fundamental difference between us. The Home Secretary wants to deport Mr. Molnar without regard to his rights of residence under the Withdrawal Agreement. We say that's prohibited by the proportionality requirements of the Withdrawal Agreement. That's the beef. That's the disagreement.
Yes.
If we don't persuade you that proportionality under the Withdrawal Agreement requires weight to be given to Mr. Molnar's permanent right of residence, then we've come away with without what we seek. And so that's why we say it has to be more than the UK's implementation of Article 8, because the UK's implementation of Article 8 through Part 5A negates Mr. Molnar's right of residence under the Withdrawal Agreement. So that's the difference between us. And like Mr. Hickman, I say there's no textual or contextual warrant to throw out the principle of proportionality, because Article 22 has removed the limitation on grounds. And the idea, or the submission of my learned friend Ms. Smythe, that it's all or nothing, you either have to keep in everything that's related to proportionality, or you have to throw it all out, is a distracting Aunt Sally. The scheme is readily interpretable as retaining proportionality, but without limiting grounds. I say that we get proportionality first, as I said in my opening, because Article 20, paragraph 2 authorises restrictions on the Article 21 treaty right of residence. That is
just say that again. Article 20.
On the Article 21 treaty, Article 21 of the treaty right of residence. Right. I say it's the reference in Article 20, paragraph 2 of the Withdrawal Agreement to residence rights that imports the requirement of proportionality directly into Article 20, paragraph 2. And it's those residence rights, and with them the duty to apply proportionality to any restriction, were continued into the Withdrawal Agreement by Articles 13 and 15.
Why does right of residence carry that particular connotation?
Because when you read this part of the Withdrawal Agreement, it's part of a scheme in which Article 13 and 15 continued Article 21, and it's inherent in Article 21, the right of residence, that it can only be restricted on grounds that are proportionate to that right. Because otherwise, the right wouldn't be a right. It would be readily negatable. Especially here, whereas you've heard, and I think without contradiction, that the ground can be negated, the right can be negated for non-criminal conduct, subject only to restrictions in the ECHR. That's the Secretary of State's case. Now that may be right or wrong, but that's her case. But the Withdrawal Agreement imposes no restrictions itself on negating the right of residence for conduct. Perhaps not sitting a Hungarian language test under legislation that Mr. Orban might introduce. That conduct. Which would mean that the EU institutions would have no control over the protection of British citizens. Only the ECHR institutions would have that control. Now, my learned friend's answer to the argument based on Article 21 is that this court in Fair Trade glossed the AT judgment to hold that this was only carried forward for the purposes of Charter 1 rights, for example. I say that's not what AT says, and you have my submissions on AT.
Well, what do you say on Fair Trade then?
Well, Fair Trade concerned a case in which the Court of Appeal held. So first of all, it was common ground that Miss Fair Trade didn't have a permanent right of residence. And the Court of Appeal held that Miss Fair Trade wasn't exercising any rights of residence under the Withdrawal Agreement. That was the primary disagreement.
On the facts?
Yes. It was common ground that Miss Fair Trade didn't meet the conditions of Article 13(1). And my argument was that the Secretary of State, by granting her permanent pre-settled status, had waived that requirement, as I said she was entitled to under Article 13(4). The Court of Appeal said I was wrong, and she wasn't entitled to do that under Article 13(4) of the Withdrawal Agreement, and therefore Miss Fair Trade wasn't exercising any rights under the Withdrawal Agreement, and that's why she didn't enjoy protection from discrimination. Now, Mr. Molnar is accepted below and accepted on appeal to the upper tribunal, has a permanent right of residence under the Withdrawal Agreement. So we're back to the primary position in AT about what is the intention or the effect of Article 13, and that is that at least where you meet its conditions, it is a continuation of the treaty right of residence under Article 21. Before I come back to that, I just want to make a short point. It was mentioned in argument about Article 20, subparagraph 3 of the Withdrawal Agreement. Just ask you briefly to turn that up. The point was made that refers expressly to procedural safeguards in Article 21 of this agreement.
Sorry, which provision?
I'm so sorry.
Article 23.
Article 20, paragraph 3 at page 150.
150.
Yeah.
The last sentence expressly refers to it.
We say the reason why Article 20, subparagraph 3 has to be there, or is there, is because Article 35 is outside Chapter 6. So that's why Article 35 is expressly brought in. And the reference there to procedural safeguards cuts two ways, because if it was intended that Article 21 only refers to procedural safeguards in the narrow sense, one might have thought that that would be the language of Article 21, and not simply a reference in Article 20, subparagraph 3. It's a rather elliptical way to tell us that those safeguards are limited to the procedural by using that language in Article.
So what it means is such measures shall be subject to those safeguards in Article 21 that are procedural.
Yes. But if I could just take you to Article 35. Article 35 of the directive at page 239, which Article 20, paragraph 3 refers to, expressly makes provision for proportionality. That's why one only needs the procedural safeguards. Proportionality is already in there in Article 35.
Any such measure shall be proportionate and subject to procedural safeguards provided for in 30 and 31.
So in other words, the submission that Article 20, subparagraph 3 confers the proportionality protection found in the directive is a good submission, and therefore the submission that a person who is found to be guilty of fraud has, on the Secretary of State's case, greater protection than a person who's failed to attend a language exam in Budapest holds good.
So, I mean, 23 does not say such measures shall be proportionate and subject to the procedural safeguards provided for.
No, it doesn't need to, because it says the host state, etc., may adopt the necessary measures as set out in Article 35. The necessary measures, and Article 35 tells us any such measure shall be proportionate. Now, all of this is, in my submission, runs completely against the grain that the parties to this agreement intended to abolish the principle of proportionality for people falling under Articles 20, paragraph 2, 3, and 4. In my submission, that frankly extraordinary step that the European Union would have abandoned the principle of proportionality for some 5 million of its citizens living outside its borders who could henceforth be expelled for conduct, not crimes, conduct, is, in my submission, I think inconceivable. Inconceivable that the European Union would have said, you have a lifelong right of permanent residence, but any conduct can lead to you being expelled without regard to the proportionality of that consequence. Turning very quickly, if I may then, the Smythe, as I understood it, characterised grounds as one of the safeguards, yet Article 20 and 21 of the Withdrawal Agreement distinguish textually between grounds and safeguards, which at least militates against that being a submission, being a proper interpretation. Article 21 is also accepted to apply to all kinds of restrictions, not only those in Article 20. And yet, if Miss Smythe is right, Article 21 is limited to the procedural safeguards, with no proportionality protection for the Centulia case, for example. Now, there, in my submission, there's no warrant in the language of Article 21 for that. So my submission one starts with the position that Article 21 confers all of the protections of the provisions that it refers to. And then one must interpret Article 21 in a way that is compatible with Article 20, paragraph 2. And all that Article 20, paragraph 2 does is remove the restriction on grounds. And in my submission, that still leaves the fundamental principle of proportionality standing for all the cases, including these cases. But I think that the arguments that you've heard support the conclusion that this is not Act Clare. We accepted that in our skeleton argument. And that this is a case where the court might think, and I appreciate it's an unusual course, might think, especially given the impact upon the many British citizens who live in the European Union and their rights, that it's an appropriate case for the Court of Justice to give a ruling. If there's anything else that I can...
Thank you very much.
My Lord,
Mr. Hickman, that clock is slow. We do have to rise.
no, it's just because I remembered that my Lord had asked me for a list of...
Well, why don't you send that in by email?
Yes, I'm very happy to. It's very short.
And I think my Lady Justice Laing wanted a note on intention to deport proceedings.
Yes, I mean, if and to the extent it's not already covered in the skeletons, I'd forgotten that there was some discussion of it in the skeletons.
I can't say my feet.
No, I'm not suggesting you should. If you could just maybe go away and think about it, and if you think there's anything else I need to know on that point,
We shall.
please, that'd be really helpful.
Within the time, we'd like that list by email, please, to the clerks. Thank you very much. Well, we're very grateful to all of you for your submissions in this case. Not only those who've spoken, but those who've worked hard behind them, the juniors and the solicitors. This case has been prepared and conducted to a very high standard by everybody involved. We're very grateful to you. We're going to, unsurprisingly, reserve our judgments. In due course, you will be supplied with a draft copy of the judgments to enable you to correct any minor errors or typographical errors, not, of course, to re-argue the case. Please bear in mind that that is a confidential document and must not be disclosed beyond those to whom it is disclosed. It's a contempt of court otherwise. We will then, in due course, hand down a final version. At that point, no attendance will be necessary. It will be in the usual electronic way now. We'd be grateful if you would, on receiving our draft, submit a draft order reflecting our decision. Insofar as there's any disagreement amongst you as to ancillary matters, please will you prepare short written submissions which we will determine on paper. Thank you very much.